Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Have you picked up the September-October 2024 edition of the Florida Bar Journal? You should. The cover article is titled Neither Goose Nor Gander, Why Tort Reform Fails All, and was written by KKTP's Medical Malpractice and Personal Injury Department. The article calls to attention several laws that impact Floridians every day, but which very few Floridians actually know about. These laws limit the rights of individuals injured by medical malpractice on the premise that by having stricter laws, Floridians have lower medical malpractice premiums for physicians in Florida and better, more affordable health care for Floridians. Looking at data collected over 40 years, the KKTP article shows that this does not appear to be the case, and that Florida's strict medical malpractice laws serve to harm Floridians. It's a serious and important article, and it's no small thing to make the cover of the Florida Bar Journal. So congratulations to KKTP Managing Partner Jed Kurzban, Lauren Gallagher, Taylor Hill, and Camila Torres-Hamilo. Give it a read if you want to expand your mind out of immigration. After, of course, listening to these 8 cases. Our first case is Mouns v. Garland, published by the Fourth Circuit on August 28, 2024. This case is about motions to reopen, and it's a doozy, whereby the BIA has, quote, flouted its own precedents, end quote. Mr. Mouns is a native of Ethiopia, but a citizen of Yemen, who has been in the United States since 1996. His asylum application was denied by an immigration judge in 1999, affirmed by the BIA, but he has remained in the United States, and motions to reopen were then denied too. And then Yemen descended into civil war, far more recently. That resulted in Mr. Mouns filing another motion to reopen, asserting that yes, now he warranted relief, specifically based on his being a Sunni Muslim and the imputed political opinion that he supported the United States against the Houthis waging that war, I imagine. When the BIA denied reopening, Mr. Mouns moved to reconsider that denial, which the BIA also denied. But the Fourth Circuit sent it back. Right out the gate, recall, there is no numerical limitation on change country condition motions to reopen to apply for asylum, withholding of removal, or a convention against torture protection. The motion to reconsider the denial of that motion to reopen is really what's at issue here, and that was based on the BIA's asserted error of law in its denial. As we've discussed often of late on the pod, the motion to reopen standard should be governed by matter of log, matter of log, which requires that the movement merely show a, quote, reasonable likelihood, end quote, of success on the merits if the case is reopened. That's different than the off-cited matter of Coelho standard, which requires a higher showing that, quote, the new evidence offered would likely change the result in the case, end quote. Now, the regulation 8 CFR section 1003.2a requires a prima facie showing of entitlement to relief to reopen. Does that mean merely a reasonable likelihood? The BIA said so in matter of log, and the Ninth Circuit recently said so too, in Fonseca v. Garland, episode 172. In fact, said the Fourth Circuit, that's been the standard since matter of Rodriguez-Vera from 1979. Albeit denied in that case because Mr. Rodriguez-Vera murdered his wife and sought reopening to apply for former Section 212C relief. Former 212C. But the Fourth Circuit has been deferring to that standard for 24 years, en banc no less, in MA v. INS. Matter of Coelho came around in 1992, but as that, quote, decision made clear, the more stringent standard was appropriate because of the particular negative circumstances of that case, end quote. To the Fourth Circuit, it appears that the Coelho standard is for cases where the non-citizen is already statutorily eligible for relief, but the relief is denied as a matter of discretion because of significant adverse factors. Under those circumstances, we have a, quote, heavy burden, end quote, according to the BIA. But not so for the regular case where a non-citizen seeks to reopen so they can establish eligibility for the relief sought statutorily. Like asylum because Yemen has descended into civil war, for example. Back to history, though. The Fourth Circuit is explaining that Coelho was a bit more nuanced from 1992, and then came around matter of log from 1996, applicable where reopening is sought to establish prima facie eligibility for relief in the first place. And where that's the case, that's the reasonable likelihood of success standard. Coelho only potentially applies where there are, quote, special adverse considerations, end quote. So what does reasonable likelihood mean? Well, according to matter of log itself, quote, where the new facts alleged, when coupled with the facts already of record, satisfy us that it would be worthwhile to develop the issue further at a plenary hearing on reopening, end quote, you have a reasonable likelihood. The BIA should not prejudge the merits of a case at the reopening stage, explained the Fourth Circuit here, and explained the BIA in matter of log itself. It is a bit more complicated deciding when matter of log rather than matter of Coelho applies in the Fourth Circuit. It's not necessarily only when the previous decision denied relief as a matter of discretion. But the Fourth Circuit believes log and the reasonable likelihood standard the more proper test for cases like Mr. Mouns, which don't have special adverse considerations. What are those? Well, in addition to cases that are denied solely as a matter of discretion because of adverse facts, there might be cases such as matter of SYG, where the non-citizen sought reopening numerous times and submitted merely cumulative and duplicative evidence, and where the respondent was previously deemed not credible. Mr. Mouns' case isn't like that. He shouldn't have had the Coelho heavy burden. He wasn't deemed not credible, doesn't have criminal convictions or anything like that, and is presenting new evidence showing his statutory eligibility for asylum, Civil War-based evidence at that. Heck, quote, the BIA did not identify or even suggest any special adverse considerations presented by Mr. Mouns' case that could justify the use of the Coelho standard, end quote. Seems like a clear type of LOG case. And just so everybody knows for future cases, the sanctioned, quote, special adverse considerations justifying the use of Coelho go beyond the mere fact that the movements were seeking to pursue previously denied relief, end quote. Motions to reopen based on changed country conditions are special and important things, explained the Fourth Circuit. While it remains a bit case-specific whether matter of log or matter of Coelho applies in the Fourth Circuit, log seems to be the standard, absent again significant adverse factors. The lowest of which to me seems to be, quote, abusive litigation tactics, end quote, in the past. Plus, BIA precedent itself shows that significant criminal histories, including even murder, might not require application of the Coelho standard. Just saying. Relying on matter of Rodriguez-Vera and matter of SV. Anyway, this case is going back for reevaluation and possibly a grant. For as the Fourth Circuit recognizes in a footnote, Mr. Mouns, quote, has presented colorable arguments that the BIA improperly diminished and disregarded his evidence. Moreover, although the government disputes Mr. Mouns' entitlement to the relief sought, it acknowledges that his desire to avoid return to Yemen is understandable, end quote. So congratulations, Daniel Aaron Diskin, for petitioner. One more thing. Is the, quote, reasonable likelihood, end quote, of success standard even the proper one for motions to reopen? The Fourth Circuit isn't so sure anymore, given that now it doesn't defer to the agency under Chevron. The regulation says prima facie eligibility, that's what a non-citizen must show. But what does that mean in other contexts, other non-immigration contexts? And what does the change country condition motion to reopen statute say itself? All things to think about and argue before the circuit now that Chevron's dead. And of course, make sure you preserve that argument before the BIA like a jar of pickles. And that is Mouns v. Garland. Next is Matter of D. Rodriguez, published by the BIA. This case is about attempts and crimes of child abuse, neglect, or abandonment. It would appear that Mr. Rodriguez is a lawful permanent resident. He was convicted of attempted injury to a child under sections 15.01a and 22.04a1 of the Texas Penal Code for having done a very bad thing to a 10-year-old family member. Looks like he was convicted of only attempt due to plea negotiations, and immigration doesn't go behind convictions when it comes to removability. DHS alleged that it all made Mr. Rodriguez removable under I&A Section 237A2EI as a crime of child abuse, neglect, or abandonment. The immigration judge sustained that and denied LPR cancellation as a matter of discretion. The BIA affirmed. Just what Congress meant at I&A Section 237A2EI is unclear, and the BIA is now owed no deference on what it believes Congress meant. The BIA has, however, interpreted that removability provision, quote, broadly, to mean any offense involving an intentional, knowing, reckless, or criminally negligent act or omission that constitutes maltreatment of a child or that impairs a child's physical or mental well-being, including sexual abuse or exploitation, end quote. Quite the mushy definition. Mr. Rodriguez argued, be that as it may, it can't include mere attempts. After all, other Section 237 provisions expressly include attempts in their definitions, but Section 237A2EI does not. So Congress must have meant to exclude mere attempts from the crime of child abuse definition. Supreme Court precedent supports such an argument, quote, where Congress includes particular language in one section of a statute but omits it in another section of the same act, it is generally presumed that Congress acts intentionally and purposely in the disparate inclusion or exclusion, end quote. But more recently, the Supreme Court said, quote, context counts, and it is sometimes difficult to read much into the absence of a word that is present elsewhere in a statute, end quote. The BIA chose this latter guidance. After all, the I&A provisions that expressly include attempts all predate IRIRA, so it wasn't the same congressional act where attempt was omitted. Nor does the BIA see the attempt provisions as close to Section 237A2EI in the Act, either in placement or in substance. Quote, the difference in subject matter weighs against drawing a negative inference, end quote, explained the BIA. Further still, Section 237A2EI isn't the type of statute that lists or groups items, such that the absence of something is strong evidence that that item doesn't qualify. Turning then directly to whether attempt should be covered under this removability provision, the BIA explained that, quote, excluding attempt offenses from the reach of Section 237A2EI would preclude removal of convicted offenders who tried but failed to abuse children, end quote. And the BIA doesn't believe that Congress intended that. Same holds true for CIMTs and attempts, I believe, and as the BIA seems to imply in a parenthetical here. As to the Texas attempt crime at issue, the BIA explained that, quote, whether an attempt to injure ultimately results in injury is immaterial to the danger posed to the child at the moment the attempt is made, end quote. It's a two-step showing for DHS. First, DHS must show that the substantive crime, if completed, would be a crime of child abuse. Then DHS must show that, quote, the state definition of attempt is a categorical match for the federal definition of attempt, which requires a substantial step towards the completion of a substantive offense, end quote. The BIA believes the federal generic definition of attempt requires merely a substantial step and not an overt act, and here believes the Texas crime requires that too. As to abuse, well, the Fifth Circuit has already held that the completed crime matches the definition of a crime of child abuse. That's Mouns v. Garland, episode 111. The BIA explains that maybe, just maybe, all of this attempt analysis might not apply to attempted endangerment type crimes, but that's not what this case is, and that will be left for another day. As to the denial of LPR cancellation of removal, well, the BIA affirmed that denial too. Seems like Mr. Rodriguez is a pretty good guy outside his criminal history, but that history also includes arrest for domestic violence and DUI. Mr. Rodriguez argued primarily that the IJ shouldn't have relied on the police report of the attempted child abuse conviction, relying on matter of Eriguin to do so. That whole issue was discussed very recently in Rosa v. Garland out of the First Circuit, which the BIA caught too, and so distinguished. The BIA explained that unlike in matter of Eriguin, and presumably Rosa, the police report here was not simply based on, quote, uncorroborated statements of law enforcement officers, end quote, without conviction. This police report has victim statements and much more, and of course resulted in a conviction. Quote, in any event, consideration of arrest or other police reports in discretionary determinations is highly fact-dependent, end quote. Pick that fight, BIA. Considering all of it, the BIA affirmed the IJ in a comprehensive decision. A bit more about endangerment-type crimes. Appellate Immigration Judge Clark concurred and wrote separately to explain, quote, that the analytical framework set forth in the majority opinion would not apply to attempted child endangerment convictions, end quote. And that is because an attempted endangerment crime, quote, does not involve inherent danger to the child at the time the attempt is made, end quote. The appellate IJ additionally believes this holding apt and, quote, especially timely, because it appears likely that the courts of appeals will be revisiting our endangerment case law in the coming months, end quote. Very interesting. Supreme Court decisions are pending taken out of the 11th and the 9th Circuit, to be specific. And it seems like Appellate Immigration Judge Clark worries that the BIA's endangerment precedent might fall under Loper-Bright. If you have an endangerment type crime, and DHS is alleging that it's a Section 237A2EI match, do everything you can to extend your case through the next Supreme Court term and fight like hell, especially if the conviction is merely for attempt. And that is matter of D. Rodriguez. To the Fifth Circuit we go. Momin v. Jaddou, published by the Fifth on August 28, 2024. This case is about jurisdiction, but it's also about so much more. Mr. Momin is from Pakistan and entered the United States with a tourist visa in 1994. For purposes of this decision at least, Mr. Momin told CBP at his entry that his date of birth was November 20th, 1975. He was placed in exclusion proceedings at the time for reasons unexplained. He didn't show up for his exclusion hearing and was ordered excluded in absentia in June 1994. Still here 13 years later, Mr. Momin's employer filed a Form I-140 petition for him in an effort for him to adjust to LPR status based on his employment. He also included an adjustment of status application at the time and his birth certificate. During this process is when Mr. Momin first learned of that in absentia exclusion order from all those years ago. Mr. Momin then moved to reopen it, took that all the way to the Second Circuit, and won, it seems. So his exclusion order got reopened, it appears, and possible the exclusion proceedings themselves terminated. A bit unclear. Exclusion is weird. But then in 2014, USCIS denied the application to adjust status. Seems like it may have been a perm, and USCIS held that the sponsoring company couldn't show that it could pay the proffered wage. But USCIS also mentioned that the application and birth certificate included therein indicated that his date of birth was actually December 21st, 1976, making him a year younger than what he said at the border in 1994. By this point as well, Mr. Momin was married to a U.S. citizen and had 2 U.S. citizen children, and so when his employment-based adjustment application failed, he tried again to adjust status. Probably should have done that in the first place anyway. I'm sure there are reasons. Mr. Momin attached a new birth certificate with that, but then withdrew his application on the advice of counsel. USCIS nevertheless conducted a fraud investigation and determined that the new birth certificate was authentic, but that the first birth certificate and passports submitted were fraudulent. Mr. Momin applied to adjust status again in 2019. He submitted the 1975 birth certificate with evidence that he claimed showed that the 75 birth certificate was authentic and that the passports with the 1975 date were also authentic. This despite USCIS having deemed at least the passport fraudulent in the past. USCIS didn't believe him and denied after issuing a NOID, of course. Still unsure why any of this is material, though. I'm sure we're going to find out. Then again, I suppose it's without question at this point that Mr. Momin has submitted two very different birth certificates to USCIS, so one must be wrong. In any event, before USCIS denied, Mr. Momin filed an I-601 application to waive any fraud. In USCIS's denial, it deemed that application abandoned, holding that he hadn't filed the waiver application. But he had, so he sued. USCIS acknowledged the mistake and then denied the I-601 fraud waiver on the merits. This even though Mr. Momin, quote, had presented sufficient evidence showing that he and his wife would suffer extreme hardship, end quote. USCIS believed that the hardship was, quote, outweighed by the volume and length of time Mr. Momin had presented himself falsely within society, end quote. Seems like he's been using that 1976 birth certificate and birth date for a lot of official things for a long time. So Mr. Momin sued under the APA, but because of Patel, the Fifth Circuit held that it lacked jurisdiction, affirming the district court's dismissal. Even if USCIS was wrong, this is the world the Supreme Court has created with Patel. Unique and creative arguments, though, and one that to an extent has been tossed around in the litigation community since Patel. Quote, Mr. Momin's main argument is that the jurisdiction stripping provision at INA section 242A2BI applies only to removal proceedings, to which he is not subject, end quote. Remember, he was placed in exclusion proceedings, and I guess those exclusion proceedings ended. But the Fifth Circuit doesn't see the jurisdiction stripping provision or Patel limited only to removal proceedings, making it, I believe, the First Circuit Court to so hold expressly and precedentially. Although based on the Fifth Circuit's citations, it certainly doesn't believe that it is the first, and so maybe I'm wrong. No discussion, though, of the fact that the text of the jurisdiction stripping provision only applies to decisions, quote, relating to the granting or denying of discretionary relief, end quote, and a limited grouping of relief at that. And well, can an immigration application truly be said to be relief if it's not presented in removal proceedings where removability has already been established by an IJ? Then again, the Fifth Circuit pointed to Justice Barrett's dicta and Justice Gorsuch's dissent in Patel to correctly point out that all the justices were well aware of what their holding would do to certain challenges to USCIS denials. Indeed, Justice Gorsuch, quote, feared that an agency may err about the facts, the law, or even the Constitution, and nothing can be done about it, end quote, which is what the Fifth Circuit has sanctioned here. Quote, Justice Gorsuch's apprehension describes the very situation Mr. Momin faces. It is not lost on us that the government has made several errors in Mr. Momin's case, which have created a Byzantine gauntlet that has repeatedly required judicial correction to even run, end quote. Not only that, it appears that there are more errors to be remedied to the Fifth Circuit, including the possibility that EOIR held long ago that Mr. Momin did not commit fraud at entry in 1994. Proof of what EOIR held in exclusion proceedings actually isn't in the record, as it can be difficult to get proof of anything that happened in immigration court 30 years ago. If it was, Mr. Momin might, just might, have an estoppel argument that might survive this harsh jurisdictional holding. But that's kind of what litigation is all about, right? Getting the facts? Mr. Momin will not have that opportunity here because of INA Section 242A2BI, Patel, and the Fifth Circuit's reading of those two things. This, despite again the Fifth Circuit saying that the evidence USCIS has relied upon, quote, inspires no more confidence, end quote, and has, quote, itself provided inconsistent statements, end quote, about the birth certificate issue. At most of the court, it might all just be a typographical error in a 50-year-old Pakistani birth certificate, not so dissimilar to the ones that USCIS itself made in adjudicating Mr. Momin's case, said the Fifth Circuit. Astonishingly, in fact, my materiality question was never answered. Asks the Fifth Circuit rhetorically, quote, what's in a birth date? Or more specifically, what's in a typographical error concerning one's birth date when there are no allegations of benefit or consequence, and thus no apparent significance? Tellingly, in oral argument, the government had no answer, end quote. So we have no idea why this birth certificate or birth date issue is material at all. one of the most powerful courts in the world, and in some circumstances, aggressive against administrative agencies, concludes its decision by stating, quote, that Mr. Momin has no recourse for what may be a series of mistakes by the government is cruel but legally compelled. We are left only with the hope that USCIS will give any future application by Mr. Momin to reopen his case careful attention, end quote. And that is Momin v. Jaddou. Our last case before we take a break is Silva Pazine v. Garland, published by the First Circuit on August 27, 2024. This case is about asylum and nexus. Miss Silva Pazine is from Brazil, but married someone named Lucas who turned out to be temperamental and aggressive. He'd even fake punch her in a terrifying manner. Both Lucas, Miss Silva Pazine, and their minor child came to the United States with student or related visas, it appears, in 2011. Lucas became more and more abusive in the United States, violently so to the point of near death, at least it seems to me. In quite the twist for the pod, Miss Silva Pazine tried to flee Lucas by buying a ticket to return to Brazil from the United States, but Lucas contacted her family and convinced her to give him a second chance. Naturally, the abuse continued horribly until Massachusetts police intervened. Miss Silva Pazine, however, told police that she hadn't been harmed because she wanted to avoid Lucas being deported. But she did move out. The threats ensued, although inside the United States. So much so that yes, Miss Silva Pazine did indeed return to Brazil, this time with 3 children in tow. Man, she could have really benefited from a U visa. Lucas continued the threats while his cousin began to surveil Miss Silva Pazine's home, monitor her, and threaten her. Lawyers harassed her on Lucas's behalf, it appears, using some pretty aggressive language. Death threats and threats to take her children were made. So Miss Silva Pazine fled Brazil for the United States with her 3 children in 2021. Apparently Lucas actually remains somewhere unknown in the US as well, and had succeeded in divorcing Miss Silva Pazine from the United States. The IJ denied asylum for a bunch of reasons, including that the harm suffered and feared wasn't on account of a protected ground as asylum requires. Not to mention that Lucas wasn't in Brazil. The BIA affirmed for many reasons. But only nexus is dispositive to the First Circuit here. The asserted particular social groups: Brazilian women, Brazilian females, and single Brazilian mothers. But to the court, actually, only Brazilian women was adequately briefed below, so that's all that this case is about. Remember, mixed motive cases are alive and kicking everywhere, really. Quote, this capacious, at least one central reason language recognizes the universal truth that it is common for persecutors to have mixed motivations. End quote. Gotta still be a central reason for the harm suffered and feared, of course. For reasons largely due to exhaustion, the First Circuit focused only on the actions and threats from the cousin and lawyers in Brazil, and not Lucas's actions in the United States or his threats. The First Circuit did not believe Miss Silva Pazine being a Brazilian woman were at least one central reason for those actions. First, the court held that yes, indeed, the IJ and the BIA considered the possibility of mixed motives for the actions, but rejected them. Second, and long decision short, the First Circuit believes that the cousin and lawyer were harming and threatening Miss Silva Pazine on Lucas's behalf, not on account of her being a Brazilian woman. For example, quote, none of the threats referenced her gender or used similar gender-based derogatory language, end quote. Nor does the record show that the 2 targeted other Brazilian women. A personal dispute, reasoned the First Circuit. Even if the country condition evidence shows that, quote, Brazil is rife with impunity for gender-based violence, end quote, that evidence is not particular to Miss Silva Pazine. Nor does it say much about the reasons for the cousin and Lucas's lawyers' actions. Might be different if they express misogynistic views, mused the First Circuit, but to be honest, probably not. Asylum, therefore, was denied. And that is Silva Pazine v. Garland. Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. With an entire team of professionals, including psychologists and mindset, task, and performance coaches, Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. Or, of course, click on the link in the show notes. Attention lawyers looking to dive into immigration law. Are you ready to master the art of marriage-based immigration? Introducing the Ultimate Marriage Green Card Course, a comprehensive resource by John Khosravi, founder of the Immigration Lawyer's Toolbox, to kickstart your journey in family-based immigration. His course offers 18 hours of engaging video content and includes monthly office hours for your questions. You'll analyze and learn, through the statutes, regulations, case law, and real-life practice, essential topics like 212 inadmissibility, 245 adjustment, consular processing, and the affidavit of support requirements. The course will also cover practical office procedures, consultations, and sales techniques. Plus, you'll receive helpful samples and templates to streamline your practice. As a limited-time special bonus, the Immigration Lawyer's Toolbox is adding the recordings of an all-day O1 seminar with the best O1 lawyers in Los Angeles. Go to immigrationlawyerstoolbox.com and click on the course link, or email John at info@immigrationlawyerstoolbox.com to sign up. Reference me, Kevin, or the Immigration Review Podcast and get an additional 10% off. Or, of course, click on the link in the show notes. Welcome back to 3 from the Ninth Circuit. First is Dominguez Ojeda v. Garland, published by the Ninth on August 29, 2024. This case is about reasonable fear review. Mr. Dominguez Ojeda is from Peru. Looks like he's been ordered removed and actually removed in the past, and ICE reinstated that order of removal in 2023. Mr. Dominguez Ojeda expressed a fear of return and so was given a reasonable fear interview with an asylum officer. But the asylum officer didn't believe that he, in fact, had a reasonable fear. Mr. Dominguez Ojeda discussed a variety of threats and harms by the Peru Libre Party against him and even his dog. The significance of that I very much can appreciate. 5 events in particular. If true, they seem like plausible claims to relief to me. Unsure why the asylum officer denied, but the officer did, and Mr. Dominguez Ojeda sought review by an immigration judge. The IJ did review, of course, but refused to accept new evidence that Mr. Dominguez Ojeda sought to submit, believing, quote, it would be fundamentally unfair to conduct a de novo review of a record that contained additional evidence and testimony that the asylum officer could not consider in the first instance, end quote. Fundamentally unfair to whom? One might reasonably ask. The Ninth Circuit did in fact ask such a question, judicially of course, and remanded. Just an aside, just remember how fast all of this is happening per the statutory and regulatory frameworks. These are not full-on asylum or withholding of removal hearings with lots of time to get evidence. This stuff is usually happening from detention in 2 to 4 weeks from start to finish. And remember still, this is just the threshold stage of whether a non-citizen can even apply for withholding of removal and cat protection in full-fledged withholding-only proceedings. Quote, it does not take much to show a reasonable fear, end quote. It's just a 10% showing, explained the Ninth Circuit. When an asylum officer finds there is no reasonable fear, an IJ reviews that determination de novo. No deference. Quote, the reasonable fear hearing is essentially another screening hearing at which the IJ determines whether the petitioner has a reasonable fear, thereby warranting a merits hearing, end quote. Under Ninth Circuit case law at least, the IJ, sitting de novo, has discretion to consider new evidence that a non-citizen obtained after the asylum officer's decision. Or I guess even before it. The IJ isn't required, but can take in new evidence not considered by the asylum officer. If they refuse to consider the new evidence, it looks like the IJ must explain his or herself. Relegated to a footnote, of course, though, the Ninth Circuit then explains, quote, IJs should exercise their discretion liberally to consider new evidence at reasonable fear review hearings, end quote, end period. For purposes of this decision, then, it all means that the IJ was wrong when he concluded that he lacked authority to consider the new evidence at all. The Ninth Circuit reads the transcript as the IJ having expressed this belief multiple times that he couldn't take in new evidence no matter what. And that's about it. Remanded. Not entirely sure under what circumstances an IJ in the Ninth Circuit properly exercises her discretion to exclude new evidence during a reasonable fear review, but given that quote I just mentioned, well, I suspect the reasons better be good. And of course, congratulations Silvan S. Ayala for petitioner. And that is Dominguez Ojeda v. Garland. Next up is Meza Carmona v. Garland, published by the Ninth Circuit on August 26, 2024. This case is about U.S. citizenship. True, Mr. Meza Carmona was born in Mexico in 1968, but his mother Victoria was a U.S. citizen. She was not married to Mr. Meza Carmona's father, at least not yet at the time of the birth. That meant that under the old law applicable in 1968, Mr. Meza Carmona automatically became a U.S. citizen only if his mother was physically present in the U.S. for a continuous period of 1 year before Mr. Meza Carmona's birth. Now, the mother Victoria lived in the United States as a child, but as a child went to live with her godmother in Ciudad Juarez, where Mr. Meza Carmona was eventually himself born. Victoria married his father and the whole family moved to Arizona when Mr. Meza Carmona was 5 years old. And heck, Victoria even applied for a certificate of citizenship for Mr. Meza Carmona way back when in 1975. The problem was that at the time, Victoria messed up and said that as a child, she had only lived in the United States for a few months, not the 1 year continuously required under the old citizenship law. So Mr. Meza Carmona's certificate of citizenship was denied in 1975. Mr. Meza Carmona got his green card, though, but was ordered deported in 1988 after some likely deportable convictions. He re-entered without authorization, and DHS initiated removal proceedings against him in 2012, rather than, I suppose, reinstating that final order of deportation. In those removal proceedings, Mr. Meza Carmona asserted that he was actually a U.S. citizen. Everything was denied, but the Ninth Circuit sent that dispute to a district court for review, as occurs when the claim is possibly legitimate. The district court judge denied, and the Ninth Circuit here affirmed that. Remember, this is an old citizenship law that doesn't apply now, but it applies to all times material to this case. And it's really about the mother Victoria's 1 year continuous physical presence before Mr. Meza Carmona's birth. Here, the Ninth Circuit held that, quote, to meet the requirement of being physically present in the United States for a continuous period of 1 year, a person claiming citizenship must show that the person's mother stayed in the United States without leaving throughout that period, end quote. That's based on a reading and comparison of terms used in some very old immigration laws and old Supreme Court decisions interpreting those old terms. Now, way back in the 1970s, after that denial, Victoria had submitted an affidavit from the godmother, swearing that she, Victoria, quote, lived with her approximately 2 years, end quote, in El Paso, Texas. But to INS way back then and the Ninth Circuit now, that's not good enough. Because it doesn't foreclose the possibility that Victoria was in fact leaving Texas and going to Ciudad Juarez during those early years in the United States, if only to visit or something like that. After all, the record does show that the godmother regularly renewed her own border crossing cards during this relevant period. It's possible that the godmother was taking a young Victoria back and forth between El Paso and Ciudad Juarez, which, as we all know, are right next to each other. And astonishingly constitutionally significant. But that is immigration law. Now true, there was literally no evidence that Victoria had in fact visited Mexico during this time period. And it's very possible that she did have the 1 year continuous physical presence in the United States in those early years of her life. But as so often occurs, the absence of evidence in immigration hurts the non-citizen, or asserted citizen in this case. It was not clearly erroneous for the district court judge to conclude that, taken in totality, it was more likely that Victoria had visited Mexico right across the border from El Paso during this period of time in her early life. And that little fact, or possible fact, is what's going to get Mr. Meza Carmona deported from the United States, likely forever, because he's not going to be able to show, and couldn't show here, that he derived U.S. citizenship from his mother. And that is Meza Carmona v. Garland. Rounding out the Ninth Circuit, we turn to Zia v. Garland, published by the Ninth on August 26, 2024. It's a simply devastating jurisdictional holding for your listening pleasure. Mr. Zia is from Pakistan. In 2012, and while in Pakistan, he married a Miss Haq, who is a U.S. citizen. Mr. Zia was granted a conditional immigrant visa shortly after that and moved to the United States to live with her in Chicago in 2014. But it didn't last long and they divorced later that year. So here's Mr. Zia, a conditional LPR in the U.S., and he needs to petition to remove his conditional status within 90 days of the 2-year expiration. Usually that's a joint filing with his wife, but they're divorced now, right? So he needs an exception. There is an exception based on a divorce so long as the marriage was entered into in good faith. And that's what Mr. Zia applied for. And that's what USCIS denied, placing him in removal proceedings for an IJ to review that de novo. Not only did the IJ agree with USCIS, but the IJ found Mr. Zia not credible. The BIA affirmed, further deeming Mr. Zia's challenge to a somewhat indiscernible transcript as not sufficient to require a remand. And well, the Ninth Circuit held that it couldn't review any of it, or at least the important stuff. For decades, it has been the law in the Ninth Circuit, and really everywhere probably, that circuit courts can review the agency's denial of an I-751 petition that seeks to waive the joint filing requirement based on a good faith bona fide marriage. No longer, said the panel, believing it unbound by prior precedent because of the Supreme Court's recent decisions in Garland, Patel, and Wilkinson. Recall, Patel concerned INA Section 242A2BI, which applies to only 5 forms of immigration relief, and I-751 waivers are not one of them. Due to the Supreme Court's reasoning, though, that section now applies to bar review of any, quote, judgment regarding the granting of relief, end quote. That is, the 5 specific reliefs. And Patel held that such bar applies broadly to even disputed factual questions related to the granting of that relief, like even initial inadmissibility determinations in the relief context. Indeed, in Patel, it even applied to whether Mr. Patel was inadmissible and therefore barred from the relief in the first place for making a false claim to citizenship. Not only did Congress see fit to implement this devastating statute in 1997, now so much more devastating because of the Supreme Court's decision, but Congress also implemented INA Section 242A2Bii, which bars review of, quote, any other decision or action of the Attorney General or Secretary of Homeland Security, the authority for which is specified under this subchapter to be in the discretion of the Attorney General or the Secretary of Homeland Security, end quote. Most relief is discretionary, explained the Ninth Circuit, including an I-751 waiver to the joint filing requirement. But still for decades, the general view was that this latter statute served to primarily preclude circuit review of the discretionary determination itself. That is, the decision whether, as a matter of discretion, the non-citizen was a good enough person to warrant the relief when statutorily eligible. The purely discretionary fuzzy holding. Because after all, INA Section 242A2D requires circuit review of questions of law and constitutional questions. No longer, said the Ninth Circuit panel. True, Patel isn't directly on point because it regards a different subsection, but both subsections apply to, quote, any judgment, end quote, of the BIA, as well as decisions or actions that are discretionary. The 2 subsections are close together, explained the panel, which expressly chose in this decision to read the jurisdiction stripping provision and the reasoning of Patel, quote, expansively, to cover all determinations made in support of a grant of discretionary relief under subsection II, end quote. Faced with a good faith choice, the Ninth Circuit extended Patel and cut off federal court review further to non-citizens. It's complicated stuff, I know, all this jurisdictional reasoning. But we're stuck with it until the Supreme Court and circuits conclusively explain what Patel and all those other decisions mean. again here, and although the real issue in an I-751 waiver is whether the marriage was entered into in good faith, it's still technically a discretionary form of relief, bringing it under subsection II, explained the Ninth Circuit. And if Patel applies to that subsection as well, as the Ninth Circuit just held, well, that's going to bar review of disputed factual questions. In this case, the facts are very much in dispute. Mr. Zia disputes the good faith nature of his marriage, and the agency disputes his credibility. So Mr. Zia is in serious trouble. Will Wilkinson save him? No. Wilkinson, from this term recall at the Supreme Court, held that the application of agreed-upon facts to a legal standard could be reviewed, even if the form of relief was expressly barred by I&A Section 242A2B I. So presumably that rule would also apply to I. But the reason is because it becomes a mixed question of law and fact then, making Guerrero La Spria governing and making it saved by I&A Section 242A2D. Not so here again. No one believes Mr. Zia. The facts are in dispute. It's not simply application of undisputed facts to a legal, good faith marriage standard. Plus all that dicta from Justice Sotomayor and Wilkinson about the unreviewability of adverse credibility findings under such circumstances. Reasoned the Ninth Circuit. True, the Ninth held that yes, if the facts weren't in dispute, Wilkinson would have saved review, notwithstanding the Supreme Court's decision and the Ninth Circuit's decision to expand Patel into the realm of I-751 waiver petitions. So there's that. But the facts are in dispute, so no review. Moving on to the final argument, the Ninth Circuit didn't see a due process violation in the IJ court transcript having 77 indiscernible markings. The Ninth Circuit so held because it didn't see any prejudice from the incomplete transcript. Later testimony, for example, apparently cleared up a lot of the indiscernible stuff. The takeaway from this decision, really, to me, is that an adverse credibility finding made in the context of any form of relief covered by I&A Section 242A2BI or II is now going to probably destroy the ability to get circuit review. Unless perhaps you're challenging the adverse credibility finding itself? I don't know. It seems really bad for non-citizens. For what it's worth, remember, none of this stuff applies to asylum cases. And that is Zia v. Garland. I know you don't want to, but we must conclude the week with Lal v. USCIS, published by the Third Circuit on August 27, 2024. This case is about U.S. citizenship, and it's a rough one. Quote, "We can readily appreciate how bitter this result is," end quote. Let us begin. Mr. Lal came to the United States on a visitor visa from Trinidad and Tobago at 15 years old in 1988. He became an LPR in 1990 while living with his adoptive parents, 17 years and 9 months old. The next month he applied for a certificate of citizenship, claiming derivative citizenship through his adoptive parents. Unlike so many people on the podcast, he was on top of his immigration situation. And everything he put on his application was true, correct, and accurate, explained the Third Circuit. No fraud. Former INS interviewed him and swore him in July 1991, after he turned 18 years old. Quote, "Critically, however, the INS examiner incorrectly recorded that Mr. Lal's adoptive parents were also naturalized on April 5, 1991, even though Mr. Lal's application reflected the accurate dates of 1975 and 1979, end quote. INS just messed up. We'll see why that matters in a sec. Now, INS actually caught this problem a few months later, sending a letter to the Department of State saying that actually it appeared that Mr. Lal wasn't entitled to derivative citizenship as he wasn't interviewed until he turned 18 years old and wasn't sworn in until that time either. It's a bit of a separate issue from when Mr. Lal's parents derived citizenship in the first place. And it's all going to get mushed together in this decision. Quote, "The mills of government at times grind very, very slowly. Appallingly so in this instance. 21 years passed, and in December 2012, while Mr. Lal was serving a sentence for a drug conviction, USCIS finally notified him that it intended to administratively cancel his certificate of citizenship," end quote. Can you imagine getting that letter? Because naturally, Mr. Lal probably didn't get the memo sent to the Department of State in 1991. He's learning that he's not a citizen for the first time while in prison. In fairness, he had a lot of cocaine. The former derivative citizenship law applicable in 1991 applies. And the real issue wasn't so much about whether he was 18 years old at the interview and when he was sworn in. The problem to USCIS and the Third Circuit is that Mr. Lal did not enter or reside in the United States at the time that his adoptive parents naturalized in the 1970s, meaning that he was not eligible to derive citizenship through his adoptive parents under the former citizenship provision. It's for this reason that USCIS intended to cancel his certificate of citizenship, which USCIS did in fact cancel, additionally explaining that he hadn't derived citizenship under current derivative citizenship law either, and that other provisions weren't even potentially applicable to his case. Mr. Lal was in a lot of trouble. Now, former INA Section 322 allowed parents and I suppose adoptive parents to apply for their children to naturalize, as opposed to automatic derivative citizenship, so long as everything, including the oath ceremony, occurred before the child turned 18. But that didn't happen here either, remember? Even construing what had occurred in 1991 broadly as being a naturalization application and not a derivative certificate of citizenship application. So again, Mr. Lal was screwed. So he sued. A magistrate judge and district court judge ruled against him. It got even worse, because while all of this litigation was going on, DHS initiated removal proceedings, Mr. Lal lost, and he was physically removed to Trinidad and Tobago. And he will not be returning. The Third Circuit affirmed the lower court because, well, the law is the law. Quote, at that time, there were 3 potentially relevant pathways for Mr. Lal to become a U.S. citizen, Section 320, 321, or 322 of the INA, as it existed then. Mr. Lal fails all 3, end quote. And Mr. Lal actually conceded as much before the Third Circuit, because the law is the law. Quote, the fact that Mr. Lal was issued a certificate of citizenship does not change that fact. A certificate does not confer citizenship, end quote. Shudder in your boots, all you certificate of citizenship holders. It's just prima facie evidence of citizenship, explained the Third Circuit. U.S. citizenship is a question of law, always, and really, regardless of whether someone has a certificate or not. This isn't the same as denaturalization proceedings, where the government would have had the burden and the person who would be denaturalized had a whole bunch of constitutional rights and protections. These proceedings, explained the court, are simply about whether Mr. Lal is a U.S. citizen, recognizing a legal truth that has or has not always existed. And here, Mr. Lal has never been a citizen. He just got a certificate of citizenship as a mistake. Which is why Mr. Lal argued that the government is stopped from taking away his citizenship. And the Third Circuit is sympathetic. Quote, the staggering ineptitude in leaving Mr. Lal and his parents under the impression, for 21 years, that he is a U.S. citizen, when in fact the government has known practically from the start that there was a mistake, is what we turn to next, end quote. This is just me, but after all, who knows what Mr. Lal would have done if, in between 1991 and his criminal activity, he believed himself only an LPR and not a citizen. Probably would have applied to naturalize, no? Now, quote, the doctrine of equitable estoppel can apply to the government in the immigration context, end quote. To prevail on such a claim, the plaintiff must establish 1. A misrepresentation, 2. Upon which he reasonably relied, 3. To his detriment, and 4. Affirmative misconduct. The problem to the Third Circuit, though, is that citizenship is like no other immigration benefit. To the Third Circuit, old Supreme Court precedent stands for the proposition that you can't get citizenship through equitable estoppel. All requirements must be complied with. So keep equitable estoppel in mind. It's just pretty hard, if not impossible, to get in the citizenship context. The Third Circuit concludes, after again chastising the government, to say, quote, of course, it is Mr. Lal's own subsequent criminal conduct that has brought the consequences of the government's dereliction down on his head. Still, that dereliction has fundamentally changed Mr. Lal's identity and place in the world. He turns to us for assistance, but we cannot provide the relief he seeks. Not every wrong is ours to right, end quote. Kind of a theme on the podcast this week. And that is Lal v. USCIS. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.